Good afternoon to everyone, and welcome to the second edition of the Emeritus Academy Lectures. My name is TK Daniel, and I'm chair of the Emeritus Academy for 2022-2023. Trying to see myself.
Library, I think.
Oh,
Now I got it.
that TK.
The topic
Oh, they're sticking Brigida.
of the lecture for today is redistricting reform in Ohio, where did it go wrong? And we have a very special guest, Professor Richard Gunther, who is going to talk about this. Dr. Gunther is obviously a professor of political science at Ohio State. He is the international coordinator of the 30-country Comparative National Elections Project. From 1989 through 2000, he served as co-chair of the subcommittee on Southern Europe of the American Council of Learned Societies and the Social Science Research Council. Dr. Gunther is author or editor of 15 books and over 100 articles or book chapters, most of them dealing with political parties, electoral behavior, the impact of the media on politics, and transitions to democratic rule. He is a recipient of the Ohio State University's Awards for Distinguished University Service and a Distinguished Scholar. He has been working on redistricting reform in Ohio for 17 years and was one of the 5 negotiators who drafted the amendments to Article 11 of the Ohio Constitution that was ratified by 71% of the voters in 2015. He also participated in the 2018 negotiations that added Article 29, parentheses, congressional redistricting, end of parentheses, to the Constitution, as well as in unsuccessful constitutional reform efforts in 2005, 2010, and 2012. Dr. Gunther, please.
Yes, indeed. Thank you very much for inviting me to this talk. This is actually part 2 of my overview of redistricting and redistricting reform efforts in Ohio over the previous several decades. My last presentation occurred prior to the beginning of the redistricting process, but after the 2 referenda that had modified the Ohio Constitution to bring about change in the way that districts for the state legislature as well as for Congress are drawn. That, I must say, was a much more optimistic talk than what you're going to be hearing today, unfortunately, because much of what we had attempted to do with regard to these constitutional reforms has somehow been sidelined. Today, I'm going to be presenting a detailed analysis of redistricting in Ohio and how and why we went off the tracks, as well as an overview of how redistricting has affected representation of the 2 major parties in other states around the US. And I think we'll have a pretty lively discussion in the end concerning all of this. So let's begin with an overview of redistricting. And there we go. Redistricting in Ohio. No, there we go. And setting this in the overall context of what redistricting is all about. The United States Constitution and US Supreme Court rulings require that seats in the House of Representatives and state legislatures be apportioned roughly equal population size. And this in turn requires that state legislative and congressional district maps be redrawn in accord with census data every 10 years. Unfortunately, in doing so, district boundaries can be drawn that greatly favor one party over the other. This has characterized Ohio over at least the past 3 decades, although the development of new computer software packages has made the distorting impact of partisan redistricting increasingly unfair and now very, very extreme in its impact. It was hoped that the constitutional amendments passed by the voters in 2015 and 2018 would have ended this undemocratic process. Instead, the redistricting process that has unfolded over the past year has been hijacked, and gerrymandering is very much alive in Ohio. Gerrymandering is the practice of stacking the deck in favor of the candidates of one party and underrepresenting its opponents by drawing district lines in a manner that effectively determines which candidate will win. And in my last presentation to the Emeritus Academy, I demonstrated with hypothetical and real examples of how that works. Now, this practice dates back to at least 1812. It was named after Massachusetts Governor Eldridge Gerry, who created a district that looked like a salamander. And this is the classic cartoon in the Boston Gazette from 1812, showing the salamander and how it relates to the various counties in Massachusetts. Our current State House and Senate and our congressional districts were gerrymandered in the 2011 redistricting process in such a manner that Republicans are substantially overrepresented in these bodies and Democrats are underrepresented. And this involved the application of two different strategies. First, packing, in which you load supermajorities of Democratic voters into a very few districts, thereby wasting many Democratic votes that otherwise might have elected Democrats in neighboring districts. The second of these strategies is cracking, in which you take the core areas of support for the opposition party and split these communities, scattering their votes into several districts with overall majorities supporting the other party. The most extreme example of packing is the 11th Congressional District, which in 2020 was won by Marcia Fudge with 80.1% of the vote. And the best example of cracking is right here in the 15th Congressional District, which used to be somewhat competitive and compact, including Franklin, Union, and Madison counties, but which in 2011 was redrawn to dilute the Democratic vote in Franklin County by swamping it with conservative voters from 11 counties, stretching from Clinton County in the west to Athens and Morgan counties in the east, as can be seen in this following map. And the 15th Congressional District is the light green that grows out of the southwestern part of Franklin County. And as you can see, it stretches all the way in the west from Clinton County, almost on the verge of the outskirts of Cincinnati, all the way to Athens and Morgan County in the east. Let me apologize in advance. I have a very bad cold, and I hope that I'll be able to avoid too many coughs. The net result of gerrymandering in Ohio is that for both our representation in Congress and in the Ohio General Assembly, there is substantial overrepresentation of Republicans as a result of that 2011 gerrymander. For the U.S. House of Representatives, in 2020, Republican candidates received 56.5% of the vote, but won 75% of the seats. For the Ohio House in 2020, 57.7% of the vote yielded 64.7% of seats, a 64-35 Republican supermajority. And for the Senate, where only half of the members are elected every cycle, in 2018, 61.5% of the vote won 93.8% of the seats. And in 2020, 47.3% of the vote won 58.8%. creating a supermajority in the Senate of 25-8. Now, the root of the problem is that congressional district boundaries were drawn by partisan politicians in the legislature, and there were no constraints on the ability of the majority party in the legislature to gerrymander congressional district boundaries, subject only to population size requirements and the Voting Rights Act. That is, the Ohio Constitution included no restrictions or guidelines concerning how districts were to be drawn. The Ohio Constitution made it possible for a party that held a majority in the legislature in 2011, that was Republicans, to create a congressional district map that would greatly favor their own candidates. District boundaries for the General Assembly, that is the Ohio State Legislature, were to be drawn by an apportionment board composed of a somewhat different set of partisan politicians: the governor, secretary of state, the auditor, and one representative for each party from the legislature. And the board's decisions were made by simple majority vote. Thus, whichever party won 2 of those 3 statewide offices was largely free to do whatever it wanted in creating legislative districts. In short, both for Congress and the state legislature, partisan politicians of the majority party were free to draw district boundaries in a manner that would benefit themselves. Over the past 4 decades, there have been several unsuccessful attempts to reform the system, including citizen initiatives that were placed on the ballot in 1981, 2005, and 2012. But in 2015 and 2018, we succeeded in amending the Ohio Constitution in ways that we thought would constrain, if not eliminate, gerrymandering. These reforms altered both the criteria that were to be followed in drawing district lines and the processes to be followed. Accordingly, the 2022 district maps for the state legislature were to be drawn using procedures and criteria established by the constitutional amendment of 2015, which was supported by a vote of 87-10 in the Ohio House, by 28-1 in the Senate, and by 71% of Ohio's voters in the 2015 referendum. And congressional district boundaries were drawn under constitutional provisions passed by a vote of 31-0 in the Senate, by 83-10 in the Ohio House, and by 75% of the voters in the 2018 referendum. I was a member of the 5-person working group that drafted the 2015 constitutional amendment, and I'm the primary author of Section 6, which we'll return to at various points in this talk. Let's have a look at how redistricting was to be done for the Ohio General Assembly. According to the 2015 constitutional revisions, a new redistricting commission was created consisting of the governor, secretary of state, the auditor, and 2 Democrats and 2 Republicans, that is 1 each from each party, selected by the legislative leaders. The most important change, though, is that 4 votes out of 7 instead of a simple majority of 3 out of 5, plus at least 2 votes from the minority party, are needed to pass a plan that would be valid for the full 10 years. In the absence of that minority party buy-in, a plan would only be valid for 4 years. Now, that latter provision was something that was strongly recommended by the Republican member of our 2015 working group, who argued that in the absence of bipartisan support, limiting the new maps to just 4 years would serve as a sufficient disincentive against gerrymandering. Another set of procedural reforms called for public engagement in a more open, transparent process. Quoting from Article 11, Section 1C, quote, "Before adopting, but after introducing a proposed plan, the commission shall conduct a minimum of 3 public hearings across the state to present the proposed plan and shall seek public input regarding the proposed plan. All meetings of the commission shall be open to the public." Now, let me leap ahead to give you the answer to this one. None of this was done. There were 8 different redistricting maps that were presented that were approved by the Redistricting Commission. None of them was preceded by this mandatory 3 public hearings across the state. But that's not the only way in which there was a departure from what the Constitution should have dictated. Most importantly, the 2015 constitutional reform added additional district standards to Section 6 of Article 11. And bear these carefully in mind because they're really quite crucial. 6A states, no General Assembly district plan shall be drawn primarily to favor or disfavor a political party. 6B states, the statewide proportion of districts leaning towards each party shall, quote, correspond closely to the statewide preference of voters in statewide elections over the previous decade. And C, the General Assembly district shall be compact. Section 6B is especially important, I should add, because not only is it the only constitution in the United States that includes proportional representation, but this proportional representation is now embedded in the Ohio Constitution, and was followed for the most part for the General Assembly after it got past the first map. I'll talk about that in a moment. Now, what emerged from this process? We still don't know, believe it or not. 5 sets of maps have been approved by the Ohio Redistricting Commission, but have been struck down by the Ohio Supreme Court as unconstitutional. This conclusion was reached repeatedly by a 4-3 vote on the court that included the Republican Chief Justice Maureen O'Connor. And it should be noted that O'Connor must retire from the court at the end of this year because of age limits. On May 27th, a 3-judge federal panel, 2 of whom had been appointed by President Trump, ruled that it was necessary to select a map out of those that had been proposed previously so that a primary election could be held on August 2nd. It selected the 3rd of 5 maps approved by the Redistricting Commission, even though that map is unconstitutional. Let's examine some characteristics of 2 of these maps to understand why they were rejected by the Ohio Supreme Court. The first map was drawn by the Republican staff of the Ohio House and Senate, not by the bipartisan commission. It was presented to the Redistricting Commission on the morning of September 15th and was approved by the Republican majority of the commission shortly after midnight, whether you call it that same day or the next day. It was all one continuous meeting. Even the governor and the Secretary of State questioned the constitutionality of the maps and complained that they were completely marginalized from the creation of these maps. Nonetheless, they voted for them. The first map would have created 62 Republican-leaning districts and 37 favoring Democrats. This violated both proportionality and fairness criteria of Section 6A and 6B. The Republican sponsor of the maps claimed that this was okay because the criteria in Section 6 were merely, quote, aspirational, end quote. The Supreme Court firmly rejected that assertion, and all subsequent proposals at least nominally accepted the proportionality criterion. The third map, submitted and approved by the Ohio Redistricting Commission, is the interim map that will be used in the 2022 election. So let's examine it more carefully, in particular concerning why it was rejected as unconstitutional. It created 54 Republican-leaning House districts, and the sponsors claimed 45 Democratic-leaning districts. And this appeared to comply with the proportionality criterion of Section 6B, which calls for a 54-45 distribution of seats between the 2 parties. So how is it not constitutional? Because it counts 19 toss-up districts as Democratic leaning. The same is true of the Senate. And let me show you the actual data from the Senate so you can see what a fine line this is drawing here. Now, mind you, proportionality should be 18 Republican and 15 Democratic districts. Instead, the Redistricting Commission drew 18 Republican, 7 Democratic, and 8 toss-up districts, which the sponsors counted as Democratic. But now look at how slim these margins are. A switch of just, if in fact there were, let me switch over here where you can see the text. If voters were to continue to support the same party that they had over the previous decade, this would produce a proportional outcome. But what would happen if in a future election, there were a uniform shift of just 2% of the vote from Democrats to Republicans? All 8 of the toss-up districts would go to the Republicans, giving them a supermajority of 26 out of 33 seats in the Senate, or nearly 79% of the seats, in an election, a hypothetical election here, in which they would have received just 56.3% of the vote. Conversely, what would have happened in an election in which there were a shift in the other direction, with 2% of the voters shifting from right to left, that is, from the Republicans to the Democrats? Nothing. There would be no pickup of seats by the Democrats, who would remain in the minority with just 7 out of 33 seats. The same would occur in the Ohio House, where a 2% shift of the vote from left to right would flip all 19 toss-up seats, creating a Republican supermajority of 73% of the seats in an election in which they would have received 56.3% of the vote. In short, the 54-46 proportion set forth in the Ohio Constitution would serve as a ceiling for the Democrats, but a floor for the Republicans, whose projected margins of victory are sufficient to protect them from all but the most lopsided of wave elections. Excuse me. The asymmetrical nature of these margins violates the fairness criteria of section 6A, leading the court to reject this map as unconstitutional. The Ohio Supreme Court also found fault with the process through which this map was drawn. In the words of the court's ruling, quote, "The Democratic members of the commission had no opportunity to provide input in creating the map, and then had no meaningful opportunity to review and discuss it or to propose amendments. It is clear that the commission again adopted a plan drawn up by employees of the Republican caucuses who, working for the Speaker of the House and the President of the Senate, Senate President Huffman and House Speaker Cupp, did not allow the minority party commission members to provide input, much less to let them participate in its creation. Nor does the record indicate that the other members of the commission, the statewide office holders, engaged in any map drawing. The process was controlled entirely by Senate President Huffman and House Speaker Cupp. In short, the majority party leaders of the House and Senate and their staff aides drew district boundaries for their own chambers and even for themselves as individual candidates. And this really is an unacceptable conflict of interest. But the court's principal objection to these maps involved the substantive outcome of the process. Quoting again from one of the rulings of the court, "The core of our determination is the plain language of Article 11, Section 6A of the Ohio Constitution. No General Assembly district plan shall be drawn primarily to favor a political party or disfavor a political party. And the evidence here shows that the second revised plan, like the first two plans, was drawn primarily to favor the Republican Party and to disfavor the Democratic Party. The remarkably one-sided distribution of toss-up districts, it is evidence of an intentionally biased map, and it leads to partisan asymmetry." The court's ruling also dealt with Section 6B. Competitive districts must either be excluded from a proportionality assessment or to be located to each party in close proportion to its statewide vote share, the court ruled. The court then ordered the commission to reconvene and, quote, "draft an entirely new General Assembly district plan that conforms with the Ohio Constitution, including Article 11, Section 6A and 6B. To promote transparency and increase public trust, the drafting should occur in public, and the commissioners should convene frequent meetings to demonstrate their bipartisan efforts to reach a constitutional plan." The commission did not do so, at least to the satisfaction of the court. It did submit two maps, both of which were rejected as unconstitutional. Substantively, they differed little from map 3. But one of them, for a time, departed markedly in terms of temporarily meeting the procedural requirements of the Ohio Constitution. The court had ordered the commission to retain an independent map drawer, quote, "who answers to all commission members, not only to the Republican legislative leaders, to draft a plan through a transparent process." The Redistricting Commission responded by hiring 2 national experts on redistricting, 1 Democrat and 1 Republican. For about a week, they worked tirelessly and collegially with a stunning level of transparency. Their deliberations were live streamed on the Ohio channel, and viewers could even follow their keystrokes and map changes on their computers. And fair maps were emerging from this process, with a 54-45 partisan distribution in the House and 18-15 in the Senate, with 3 competitive Republican and 3 competitive Democratic-leaning districts. About an hour before the midnight deadline, they announced that they had completed the House map, but needed another 45 minutes or so to finish work on the Senate map. Let me tell you that by this time, we were all very, very positive and optimistic in our view of what was happening. Boy, were we fooled. Instead, Senate President Huffman introduced a totally different plan, again, created by the Republican legislative staff and dumped on the committee without any advance warning. The ORC members were given 3 hours to read it, and after 20 minutes of discussion, it was approved along strictly party lines. It was subsequently ruled unconstitutional by the Ohio Supreme Court. What is the current status of the Ohio General Assembly maps? Well, the 5 maps approved by the Republican majority on the Ohio Redistricting Commission have all been declared unconstitutional by the Ohio Supreme Court. An interim map has been imposed by a 3-judge federal panel whose 2 Republican members, both Trump appointees, chose map 3 for the current round of elections. Republicans, some of whom have called for the impeachment of Chief Justice O'Connor, hope that a more partisan Republican Chief Justice will succeed her following her retirement at the end of this year and elections to be held in November. Barring some significant institutional change, it appears likely that we will witness Groundhog Day 6 in the next round of this saga. What about the congressional redistricting? The procedures and criteria enacted in 2018 differed from the legislative redistricting process, but the bottom line is more or less the same. 3 maps were drawn, and all 3 have been rejected by the Ohio Supreme Court as unconstitutional gerrymanders. The procedures established in 2018 are hideously complex and include 4 different pathways towards creating a congressional map, 3 of which involve the legislature. Not to waste your time, I'll just list them on the screen without discussion. That is because the 2 pathways involving the legislature were completely ignored. Not a single hearing was held to deal with redistricting. Instead, the process unfolded entirely within the Redistricting Commission, whose deliberations, again, were totally dominated by House Speaker Cupp and Senate President Huffman. The 2 Democratic members of the commission were totally shut out of a meaningful role. The criteria for drawing congressional maps largely involve rules for splitting cities and counties. No proportionality criterion is explicitly stated, but the other anti-gerrymandering principles are. So the Ohio Constitution states that if a congressional map is not supported by at least 2 minority party members of the commission, the following criteria should be imposed. No plan shall unduly favor a party. No plan shall unduly split governmental units in order keeping together counties, cities, and townships. And the districts must be compact. The Ohio Supreme Court has ruled that all 3 of the maps passed along party lines are unconstitutional, but one of them will nonetheless be used for the 2022 elections. The Ohio Supreme Court ruled the maps unconstitutional because they, first, unduly favored Republican candidates and unduly split Hamilton, Franklin, and Cuyahoga counties, employing the classic cracking strategy. This resulted in maps that created 10 safe Republican districts, 2 supermajority Democratic districts, both of which are heavily packed, and 3 highly competitive districts. Here they are. As you can see, the 2 supermajority Democratic districts are the 11th in the Cleveland area and the 3rd in Franklin County. The toss-up districts are number 9 in the Toledo area, that's Marcy Captor's district, 13, which used to be Tim Ryan's district, and number 1, which is currently a Republican district. Steve Shabbat is the incumbent, but it has now become very much a toss-up district. So we'll see what happens there. But Democrats, on the basis of this map, can really count on only 2 seats. The dates for, or rather the district margins of victory expected for Akron on the basis of past voting patterns, Cincinnati and Toledo make these true toss-up districts. What we can find then is that there are 2 safe Republican districts, Democratic districts, Cleveland and Columbus. And there are 12 very, very safe, very safe Republican districts elsewhere. And the toss-up districts are to be found in Akron, Cincinnati, and Toledo. Thus, a maximum of 5 Democrats out of a total of 15 representatives could be elected, or if there were a shift of just 2% from left to right, as few as 2 Democrats and 13 Republicans would join the Congress, which would be even more unfair than our current map. It could mean that 56% of the voters would elect 87% of our representatives in Congress. On July 19th, the court ordered the Redistricting Commission to revise their map and correct constitutional violations within 30 days. House Speaker Cupp and Senate President Huffman boldly stated that they would do no such thing, adding that they would not act on this redistricting plan until October 17th, just 3 weeks before the election. While some have called this an outrageous rejection of the rule of law, it is consistent with the Commission's strategy of running out the clock. So what went wrong with the reformers' efforts to bring representation in Congress more into line with voters' preferences? First, there was no Section 6B in Article 19, which governs congressional redistricting. Instead of a widely understood and precisely stated proportional distribution of 54 to 46, Republican versus Democratic leaning districts, the fairness criterion for Congress was based on a less precise notion of unduly favoring a party or candidates, which is a rather squishy criterion. Second, the sharp limits on the Ohio Supreme Court's ability to enforce its rulings should be eliminated. For both state legislative and congressional redistricting, the Ohio Constitution gives the Ohio Supreme Court, quote, exclusive original jurisdiction over all relevant cases. But as stated in Article 11, no court shall order in any circumstance the implementation or enforcement of any General Assembly district plan that has not been approved by the Commission in the manner prescribed by this article. No court shall order the Commission to adopt a particular district plan or to draw a particular district. What this means is that the Ohio Supreme Court is prevented from pursuing remedies to unconstitutional gerrymandering that are often used in other states, such as appointing a special master to redraw district boundaries or to impose its own revisions. 3, under no circumstances should district boundaries be drawn by employees of the majority party in the legislature. Maps were supposed to be drawn by staff reporting to the 2 parties on the commission. Instead, the staff of the majority party in the legislature, under the direct control of the Speaker and the Senate President, drew district boundaries favoring their own party. 4th, the constitutional reforms of 2015 and 2018 called for a transparent process with input from the general public. Instead, maps were drawn in complete secrecy to the extent that even other Republican members of the commission, including the governor, complained that they were totally shut out of the process. Minority party members of the commission were blindsided by the presentation of highly complex redistricting plans that they usually had only a few hours to read. And none of the 8 plans complied with the constitutionally mandated public hearings following the presentation, but before the adoption of each plan. As one of the Supreme Court rulings described it, quote, "The Democratic members of the commission had no opportunity to provide input in creating the map, and they had no meaningful opportunity to review and discuss it or to propose amendments. And it is clear that the commission again adopted a plan drawn up by employees of the Republican caucuses who work for the Speaker and the President." Fifth, the intervention of the federal court panel in ordering the adoption of Map 3 for the General Assembly is highly questionable. First, it violates the Ohio Constitution's granting of redistricting matters to the exclusive original jurisdiction of the Ohio Supreme Court. It simply takes away that power. It places a federal court in the inappropriate position of ruling on matters included within the Ohio state constitution, a violation of some of the basic principles of federalism. It runs counter to the 2019 U.S. Supreme Court's Rucho decision that federal courts should not intervene in matters of partisan gerrymandering. We're now in the midst of a constitutional crisis in Ohio. The leaders of the majority party in the legislature have not only shown disregard for the Ohio Constitution, as amended by over 70% of the voters, they have also on 8 occasions contemptuously ignored directives from the Ohio Supreme Court. We are, like Bill Murray in Groundhog Day, trapped in a recurring nightmare, but one in which the quality of democracy in Ohio is at stake. The current gerrymandered maps will establish one-party rule in Ohio with no realistic possibility that the opposition party would ever be able to win a majority of either our congressional delegation or the state legislature. By creating one-party enclaves throughout the state, they have contributed to polarization and ideological extremism. While the voters of Ohio are on average just slightly center-right, our legislature has adopted policies that are among the most extreme of any state in the union. Finally, as could be seen in the one-party dominant systems of Italy, Japan, and Mexico in previous decades, permanent incumbency has contributed to widespread corruption, as most shockingly demonstrated by the arrest and indictment of the former House Speaker and his co-conspirators for multiple felonies. While many of us are burned out by the ongoing struggle for representational fairness in Ohio, I've sadly concluded that our reform efforts were not enough. Chief Justice O'Connor is right. Change is needed. Now, how does Ohio compare with other states following the 2022 redistricting round? The following tables present disproportionality scores for all states electing 4 or more representatives to the U.S. House. And I should point out, I have never seen these data presented in this manner before. Typically, what you see, such as we saw in Nate Cohn's article in the New York Times this past week, are discussions of what happened in the latest round of redistricting. What these data that I'll be showing you indicate are that baked into many of these biases are partisan distortions that date back over decades that have simply been reaffirmed in recent rounds of redistricting. They also present the data on the number of seats won as a result of partisan gerrymandering. Now, I'll take a minute to allow you to have a look at these data. What you find is that they are arrayed from big to small in terms of the extent to which there is electoral disproportionality. Disproportionality is the difference between the percentage of the vote received by the candidates of the majority party in elections over the previous 2 presidential election cycles and the percentage of seats created that in 2022 leaned toward that party. For example, in Arkansas, the 2022 redistricting created 37% more Republican districts than it merited on the basis of votes cast in previous elections. Now, there's one problem of presentation that I had, and I'll just simply share that with you. If somebody has a better idea, please let me know. The minus 25D for Wisconsin, where did that come from? Well, it turns out that Democrats are the majority party in Wisconsin, and yet they wound up being the minority party in terms of being victimized by gerrymandering, such that the Republican Party received 25% more districts than merited on the basis of their share of the vote. Here we find that where there was a Republican disproportionality, there was a significant number of seats that went to that party. And in terms of total number of seats that were affected by gerrymandering, Ohio, Florida, and Texas contribute the most to a distortion of representation in the U.S. House, with 4 and 3 seats respectively. What about gerrymandering by Democrats? Well, we see in a couple of cases that where they have majorities, they exercise them. And in the case of Illinois, certainly this is a blatant gerrymander. The fact that Massachusetts is up here is not so much the impact of conscious gerrymandering as it is the fact that there are damn few Republicans in the state of Massachusetts. Nonetheless, what we find is that Democrats do not use the various tools of gerrymandering to the same extent as Republicans. Now, the big question from the standpoint of reform is, how do independent commissions and court decisions affect the outcome of these processes? Now, we find here that there are several states that have independent commissions: California, Michigan, New Jersey, Arizona, and Colorado. In the aggregate, what we can say is there is much less partisan distortion, but it's sort of a mixed bag. You can't guarantee that you're winding up with fair representation, with Democrats getting 10% more than they deserve in California, but Republicans getting 3 more seats than they deserve in Michigan. But the one thing that is clear is that court rulings tend to produce very fair district boundaries. And what we can find in this instance is only a couple of cases, only one case really, where there is any distortion at all, and that's Pennsylvania, where even though the Pennsylvania Supreme Court ruled in favor of Democrats and substantially reduced the percent of Republican overrepresentation, you still have a Republican bias of 2 seats. So what we can find then is that nationwide gerrymandering by Republicans, when they control the redistricting process, has yielded a net of 38 seats that otherwise would have been competitive or lean towards the Democrats. This is nearly 4 times the number of seats favoring Democrats in states where they control the redistricting process. States that use independent commissions to draw congressional district boundaries were mixed in this regard. But court-ordered redistricting produced remarkably fair districts. Well, all of this may be changed dramatically as a result of 2 cases currently being argued before the U.S. Supreme Court. One of these was argued and presented day before yesterday, and it focuses on Alabama, where a racial gerrymander has packed one district with most of the state's African-American voters. The net result is that Black voters, who constitute 27% of the population of Alabama, will win only 14% of the seats. The other case that is pending before the Supreme Court would be far more sweeping and detrimental to the quality of democracy. It focuses on North Carolina, where the state Supreme Court overturned a racial gerrymander and imposed a very fair map. Republicans representing the North Carolina legislature have appealed this to the U.S. Supreme Court, arguing that Article 1, Section 4 of the U.S. Constitution gives state legislatures the exclusive right to determine the, quote, times, places, and manner, end quote, of elections to the U.S. Congress. This independent state legislature doctrine would give legislatures carte blanche to gerrymander as they see fit, without regard to state constitutions, citizen initiatives, or court rulings. It should be noted that the chief justices of all 50 states have opposed this interpretation, which, in my view, poses a grave threat to democracy. While it would run counter to rulings by the U.S. Supreme Court in 2015 and 2019, it is worrying to note that 4 of the 9 justices of the current Supreme Court have already taken public stands in favor of this radical doctrine. In one word, beware. I'm certain that we have a number of questions out there, so let me turn it over for that.
Well, we have a number of questions in the chat already, Professor Gunther. I will tell you who they're from and what the questions are. First is from Professor Mark DeBard. Why weren't the problems with gerrymandering in Ohio that we see today anticipated by the writers of the amendments of the Ohio Constitution who had expert advice? Why were there no other states with ironclad anti-gerrymandering laws to act as an example?
Let me answer that one first before we move on. And as one of the 5 members who drafted the 2015 constitutional amendments, certainly I would have to plead guilty on that charge. However, I want to point out one thing. Politics is the art of the possible. It is not that we can sit back in an ideal world and design a perfect set of institutions. In this case, I was invited to participate in this by none other than Matt Huffman. And we were given a series of outlines that we really were not capable of changing, that many of the commitments that were made, we had no choice but to go along with. Now, we did, in fact, win the big one. So let's limit this to the General Assembly first. And that is, we were able to put into the Constitution proportional representation. We were able to put into the Constitution a fairness doctrine, which don't exist in other state constitutions. If the Supreme Court had the authority to impose a solution on this particular impasse, we would not be complaining about a redistricting process that went off the tracks. We would be touting a great victory over a fair redistricting process. Unfortunately, that one little clause in section 19 concerning the authority of the Ohio Supreme Court slipped in. I didn't pay very much attention to it. Vernon Sykes, the other Democrat on the committee, didn't pay attention to it. And as a result, we wind up with the hands of the court tied. It is incapable at this point to resolve this matter. We'll simply have to see what happens after the election. And in the end, we may wind up with a victory, but I think, unfortunately, we probably need to consider further constitutional changes.
The next question is from Professor Satyani. Seems to me that these shenanigans by polls, I assume he means politicals there, are old on both sides. Other states, both red and blue, are doing exactly this. If they go to the state Supreme Court, those judges are also from the same party, so why should we expect a different result?
In this case, I want to point out that the Ohio Supreme Court is majority Republican by 4-3. And nonetheless, despite the fact that it is a majority Republican court, it has ruled in all 8 of these cases in favor of redistricting fairness and the reforms that we enacted in 2015 and 2019. So in this particular case, I strongly praise Maureen O'Connor for having the tenacity to oppose the overwhelming majority of the members of her own party in insisting upon adherence to the Constitution and representational fairness.
We have another question by Professor DeBard. Why wasn't gaming of the new system anticipated and adequate deterrent penalties incorporated into the amendment?
I'm sorry, I missed the first. I'm sorry, TJ, I missed the first part of that.
Why wasn't gaming of the new system anticipated and adequate deterrent penalties incorporated into the amendment? And then he goes on to say, after all, constitutionally mandated school reform has been ignored without penalty for decades in Ohio.
This was probably the first and most difficult issue that we could encounter. We argued over this for a long time. How do we compel the Redistricting Commission to actually reach a decision in accord with the Constitution, giving 2 votes of the minority party to the outcome of the redistricting process? And a number of wild ideas came to the table. Lock them in and don't let them out until they have finished the job was number 1. And believe it or not, that actually had serious support among those of us who were negotiating. The minimal bottom line, I think, was the one that was adopted, and that is, if you don't get a vote of both members of the minority party, the map is valid for only 2 years. Now, the logic behind that was, number 1, candidates don't like to have to adjust to new districts simply because there are new lines that are being drawn. In fact, for the state legislature, you would have to sell your house and move to a new district in order to remain in that particular house district. There are a couple of other things as well. We had thought that there was sufficient uncertainty back in 2015 about who would control the elections, who would win the elections of 2022, that this would provide an incentive, that fear of uncertainty about who might win could serve as an incentive to be fair. Unfortunately, it didn't work out that way.
There's a corollary question from Professor DeBard. Why wasn't the eventual temporary model of drawing a map by a national expert with 1 member from each party and open, transparent proceedings incorporated into the original constitutional amendment?
They eventually did that at one point. We should have made it explicit what kind of subcommittee would exist within the commission, but micromanaging the board was a little bit beyond what we thought we could do in terms of drawing up constitutional principles. Now, I should point out that there was a near miss when we had those 2 outside experts drawing a map. They missed by approximately 15 minutes imposing a fair map. But Huffman, in particular, Matt Huffman, the president of the Senate, who was really the person in charge of this process, decided, no, they're not going to get it done in time. And therefore, we absolutely have to have a parachute, as he called it, a different bill, because they're not going to be ready with the one that the 2 parties are jointly drafting. And so they pulled the rug out literally an hour or 2 before the final deadline, and just before we could have a map submitted formally by the 2 outside experts. But it certainly gave me confidence that this particular process of drawing maps could work at some point. And if we have to make further constitutional revisions, this may serve as a positive model for emulation.
Another question from Professor Satyani. I recall reading that Maryland went, and I think the word should be through, the same shenanigans until a judge forced them maybe I am wrong.
Maryland is an interesting case because this was a Democratic gerrymander that had basically in the previous round excluded a longstanding member of Congress from his seat. And Democrats had controlled the redistricting process. They went to court, the Republicans went to court, and there was a discussion about how to proceed. That was not how it was eventually resolved. What actually happened was that Democrats and Governor Larry Hogan, who was a very fair and balanced person, I should point out, reached an agreement that they would, in fact, create one additional Republican district that would satisfy the demands of the Republican side. It wasn't the 2 members that they were demanding at the outset, but it was enough. So in this particular case, there was half a step towards fairness.
Question from Professor Sutton Ramspeck. Actually, it's a series of statements and then a question. As someone who helped gather signatures for redistricting in 2018, I thank you for your work and share your frustration, nay, anger at the way the will of the people has been trampled on. My anger is exacerbated by the fact that I formerly lived in Lima, home to both Huffman and Cup, also Jim Jordan's Seahorse District on the old map, parentheses. Now I live in North Carolina, which has had its own gerrymandering issues, but has somewhat resolved them toward fairness. Here's my question. How much hope do you have for a new constitutional referendum, perhaps for a fully nonpartisan commission like that in California?
I don't know. Let me go back to the 2012 case that you were dealing with. Here was one in which we had a citizen initiative that was very far along. We had collected 208,000 valid signatures by that time. We had already collected 208,000 valid signatures, which was just 100,000 below what we needed to put this on the ballot. It was almost certain that we would have put this on the ballot had we continued. However, at this point, the Republican leadership decided they wanted to initiate bipartisan negotiations with representatives of those of us in good government groups sitting on the sidelines, but at least chipping in our thoughts. And so we went the route of bipartisan negotiations, leading to the placement on the ballot of what became issue 1 in 2018. Why did we not continue to push our own initiative, which would not have been riddled with the traps that we currently see that are being taken advantage of? And the answer is, we had only $50,000. Think of that. Mounting a citizen initiative campaign with a budget of $50,000 going up against what we had estimated would be an $8 million campaign. We had previously lost 2 efforts at putting citizen initiatives on the ballot and passing them in that manner. And there was just no serious expectation that we would be able to pull it off. So we went along with trying to negotiate the best deal that we could. And once again, I want to point out that if there were adherence to the rulings of the Ohio Supreme Court, rather than turning their back and ignoring them, we would have fair maps, both for the US Congress and for the state legislature.
Ladies and gentlemen, we're at the end of the time for the lecture and questions today, but I'm going to keep going because this seems to be such an important subject. This comes from Professor Shubin. What effect would a United States Supreme Court decision in the Moore versus Harper case have on Ohio?
Moore versus Harper is, which one is that? Is that the independent legislature?
Yes, absolutely.
Oh, it could be horrific. it would declare that only the state legislature would set the terms for competition over congressional seats. As I understand it, and I'm not a lawyer, but I notice there are some lawyers or people with knowledge of jurisprudence in the audience, that this would mean that the kind of intervention by the Ohio Supreme Court in behalf of fairness would not be possible, that there would not be citizen initiatives that would embed in the Constitution principles that would have to be followed in drawing maps. It would be a free-for-all. And I fear that this could really trample over basic democratic rights.
This is another question from Professor DeBard. Why was the federal court ruling overruling the Ohio Supreme Court not appeal to the Supreme Court? By that, I think the person means the United States Supreme Court.
Yes, and that the answer to that is everyone was terrified over the independent state legislature's theory. They were afraid that if we were to appeal this particular decision to the United States Supreme Court, that it would not be North Carolina that would be test case, it would be Ohio that would be the test case of the state legislature's doctrine, the independent state legislature's doctrine. That's the principal reason why there was no attempt at appealing this to the Supreme Court.
This question comes from Professor Nasser. Instead of depending on the legislature or court, are there plans for a petition for a statewide ballot initiative for a process that keeps politics out of mapping? If so, by what election?
We can do that according to the Ohio Constitution, but it can only be done in 18 states, since only 18 states allow for citizen initiatives. So, there could be an increase of maybe another half dozen or so states that would pass these reforms, but it's an uphill slog. I can assure you, having been a veteran of these past initiative campaigns, they're enormously costly, they're enormously time-consuming, they're exhausting. And when you're going up against a very well-funded opposition, they often don't succeed.
And we have two questions, and those will be the end of the questions, and we will end this episode after those. The questions are by Professor Beck. So what is the recourse? Should new referenda be launched? Should outraged voters defeat Republican candidates where they can?
I think number one, we need to pay attention to the election for the Ohio Supreme Court. If there is a consolidation of Republican control of the court, i.e. the replacement of Maureen O'Connor with someone who is a more sectarian Republican Chief Justice, there's little hope that we could use the state's judicial institutions to bring about serious reform. On the other hand, if in fact there is democratic control of the state Supreme Court, persistence may pay off. And even though we have the negative example of school funding, which has been unconstitutional for over 20 years, and yet the legislature has not acted in a constitutional manner, this would be one possibility. The other possibility, and this is I almost dread, is another petition drive that would put an initiative on the ballot. On the other hand, perhaps this time, the Ohio citizens have had enough of gerrymandering. They are now educated as to what gerrymandering is, and there may be a much deeper groundswell of support for this kind of reform. Those are the two channels that I see would be relevant. Obviously, a decision by the United States Supreme Court would help. Unfortunately, they haven't shown much hint of sympathy for this, certainly with regard to the Rucha decision in 2019. And let's see what happens with regard to North Carolina and Alabama.
There's a corollary question to the one that was just asked. Redistricting will have to be done after 2024. What outcome should we expect?
I think that you're probably going to see the same outcomes unless there are more significant changes. And I just can't foresee what those might be.
This is the last question, also, but by Professor Beck. In the infamous book Plunkett of Tammany Hall, the party boss said that, quote, reformers are like morning glories, alive only in the short run, but asleep soon thereafter, end of quote. Is that correct?
Sad, but perhaps true.
Okay. Well, and Professor Sutton Ramspeck says to everyone, again, thank you for your efforts on behalf of redistricting reform and for this informative talk.
And thank you for inviting me.
You're welcome. Thank you, everybody.